Hi, I'm Cassandra Van with the Home Advisors team with Keller Williams Realty, and today I'm here with
Matthew Morrison with the MTM Law Firm.
Okay, so what got you into handling probate cases?
Well, my family is actually in the funeral business, and it kind of naturally worked out that way. My grandfather built mausoleums, my dad was in construction, and I decided to go to school and just kind of focus on that from the legal side.
Oh, wow, very cool. So tell me a little bit in simple terms, what is probate?
So probate is the process of taking assets from a person who's passed away and transferring them to the heirs or beneficiaries, whether it's through a will or when there's not a will, which is called intestate, when you use the state's will, as we call it, through statute. And it's just primarily the purpose of just conveying that interest and having that person have the ability to then sell it.
So determining who the actual owner is when the previous owner has passed away.
Exactly. Yeah.
How often is real estate involved with probate cases?
Often.
Okay.
It probably occurs 90% of the time. And most of the time when I get contacted, if it's not from somebody calling my office for somebody passing away, it's usually when a real estate company or a title company is needing to transfer the asset because they find out a little late in the game that after they are under contract, they can't sell the property because it's still in the name of the decedent. So they usually call us and we have to start that process.
Why is it important to work with an attorney who understands the probate process as it relates to real estate property?
Probate's complicated. Most attorneys don't actually practice probate. Probably about 10% do. And even those who are involved recognize the nuances that kind of come up. So there's a lot of complication, and there's special paperwork that has to be done to properly transfer those assets into the name of the beneficiaries. And there's also title that has to comply with those transfers. And if you don't follow that exactly the way it should work, there could be a problem, and you might be prohibited from selling that property.
What happens to a house when an owner passes away and there's no will?
So when there is no will, a lot of the time we invoke that state will, the statute. It's called intestate succession. It requires a little extra paperwork because we have to show proof as to who actually is entitled to receive assets. Whereas a will might kind of mention a name or two in it. You have to go through affidavits and then kind of prove that that particular, the parties involved are actually heirs to the estate.
So if there is a will, does the property still have to go through probate?
That is probably the number one misconception that tends to happen, is that most clients that come to the door have this preconceived notion that a will precludes you from going to probate, and that's actually the opposite. That would be more along the lines of a trust. So a trust is typically what's used to bypass that probate process, whereas a will is kind of the document the judge focuses on to show who actually is entitled. So you still have to go through probate when there's a last will and testament.
So what is the difference between probate for real estate and then other assets that they may have owned?
Okay, so obviously real estate has the conveyance through a deed, right? So when you are focusing on that particular asset in the decedent's name, you have to go through those extra steps, as I was mentioning earlier. You have to file a special petition called a petition to determine homestead, which actually acts as a deed to transfer that asset. Whereas other assets may not have to go through such a rigorous process. So yes, you might have a bank account in the name of the decedent, but you won't actually have to transfer that particular asset over to the beneficiary's name, just liquidate the assets through a different means. So for real estate, it's a little more nuanced.
I see, okay. Big question, how long does probate take?
Depends on the process and how much the estate's worth.
Okay.
So the homestead, actually in the state of Florida, is not considered to have value for probate purposes. So it's considered a zeroed out balance. So if the only asset's a homestead, you can probably get it done with a skilled attorney in 2 to 4 weeks. And,
oh wow,
yeah,
that's very quick.
Yeah, but that's the only asset.
Okay.
But if it's commingled with other assets, it can take about 4 to 6 months with a skilled attorney. But if you go on Google, you'll see 6 months to a year, and that's what people typically see. But if that's another reason why you'd want to hire an attorney who understands and can navigate the process expedite that experience.
Well, if only 10% of attorneys practice probate, then you need an attorney who is specifically practicing probate to get it through faster and the right way.
Absolutely.
Okay.
Absolutely.
So, who has the authority to manage the property while it's going through probate?
So every probate has a designated person that everybody wants to appoint, or unless the will states that that person is designated in the will. That's the personal representative.
Okay.
They are the person put in charge of the estate. They have to meet certain qualifications, and then they will kind of marshal the assets, pay off creditors, and then be discharged and receive whatever benefit they receive as a beneficiary, or just whatever they're entitled to.
Okay. Are we able to sell a home before the probate is completed?
Yes, you can.
Okay.
With a skilled attorney who understands the process. I say skilled because there are sometimes experiences where people don't deal with the right attorney utilizing the process correctly. But you can have special petitions that allow you to sell the property, holding assets into an account. But sometimes you have to sell quickly. If there's a foreclosure action or a tax deed sale. Sometimes it's best to try to push that forward, and then you can get the assets determined exempt at a later period of time. So you can sell before probate is complete.
Great information. How do mortgages, liens, taxes, how does that affect the real estate during the probate?
Mostly, it really depends on what you can obtain, right? So you have to have that personal representative because they're going to have the ability, once they're appointed, to go to the bank, ask for a payoff, ask for permission to get information necessary for the title company to effectuate the sale. But just like anything else, it's about the value of what you're trying to sell the property for. So you have to obviously minus the mortgage out and make sure you have that proper authority to get the information to allow the title company to complete the transaction.
Who pays the mortgage while it's going through probate?
So there's technically, you're not supposed to use estate assets to pay that mortgage. You're not supposed to. You're actually supposed to contend to the mortgage and use money out of pocket, which is reimbursable through the sale. Depending on the jurisdiction, judges will do equity because they understand that most people can't take on two mortgages. That's not fair to the beneficiaries. But the strict rule is you're not supposed to use estate assets to pay the mortgage.
I see. So if you're a designated representative, you're actually taking on quite a bit of liability with possibly having to pay the mortgage out of pocket while it's going through the probate process.
Not only is this a novel process for most people who haven't experienced probate generally, they don't realize the burden and the responsibility that follows being a personal representative. You have a fiduciary responsibility to do what's in the best interest of not only the state, but paying off creditors. And you can get into some trouble if you don't have the right guidance.
And you guide them along the way.
Yes, I do.
What are some ways homeowners can avoid having to go through probate?
So I mentioned earlier trust.
Okay.
Trust is a wonderful estate planning vehicle that you fund maybe the trust with your home, make the trust the designated beneficiary of a bank account. But the idea is when you put assets into a trust, it bypasses the need to go through probate. So that would be the best tool.
I think a lot of people, like you said, the misconception is, well, I have a will that states, what's going to happen, but you still have to go through probate, so that, isn't always reliable.
It's probably every other client that walks the door assumes that.
Understood. So how can joint ownership or a transfer on death deed or like a ladybird deed avoid probate?
So that's a very good question. So there are obviously many different ways people can have interest in property with each other. Joint could be husband and wife. By operational law, when one spouse passes, the other actually receives it automatically without the probate process. There are obviously people put on deeds that aren't spouses, of course, siblings, whatever the case may be, with joint tenants with right of survivorship, and that's when one passes. As long as that language is in there, same thing, outside of probate. And then there's the favored ladybird deed, the enhanced life estate deed, where you have life tenants, husband and wife. They have the full authority to sell that property, mortgage it, do whatever they need to do. You could do one deed, that deed, and the next day do another deed with them only involved transferring it. But the special part about it is you can add the children as remainders. So again, you're bypassing probate with this deed. There's wonderful tax benefits to it as well. It's a very useful tool. Sometimes there are reasons why you would just need that and a will, and you're, for the most part, probate proof. And when there are minors, you might want to have a trust. But trusts are kind of parallel.
Okay. If someone has a will, does it take care of all the other assets minus the real estate?
Yeah. So
Okay.
actually, what typically follows along with the trust is what's referred to as a pour over will. So if the trust isn't funded with a particular asset in the name of the decedent, you actually have to go through probate, even though you have a trust, to put that asset through the probate process into the trust. So you're still going to have a will, and the will, the idea is there's a residuals clause, residuary clause, that actually does take care of any other assets that might be out there.
So how does probate affect the value of a home?
In some cases it doesn't.
Okay.
In some cases it does. Like anything else, the traditional things that would cause a home to drop in value is it being subject to a foreclosure, tax deed sale, and the quality of the home. Generally, probate doesn't really affect the value.
So if a home's been vacant, though, because the owner has passed away, there might be some deferred maintenance that would affect the value of the home?
Yeah, in that case, yes. I mean, if you have a home that's sitting, or there hasn't been a probate performed in a number of years, and you have squatters in the home, for instance, and they may have damaged it, then yes, that would be another thing that could cause the price to drop.
Okay. So is someone able to live in the home when you're going through probate?
Yes.
Not a squatter, but like, if
heir?
it were, yeah.
Yeah. You actually tend to, most of the time, you'll have at least one person typically living in the home. It's a 50-50 chance that an heir is already living there, or they're just dealing with a situation where a parent has died, so they're just trying to sell it.
And when it goes through probate, do you always have to sell the home?
No.
Okay.
No. Actually, the process isn't just about selling the assets. Not everybody wants to liquidate them. Some people would like to hold that real estate in their name, and there's the different methods of doing that through the probate process.
So how are the sale proceeds from the home sale distributed between the heirs?
So depending on how it happens, you typically have the sale. The homestead is not considered an asset of the estate, so it actually goes straight to them from that sale, straight into their pocket. Now, like I said earlier, there's a process where you would sell it before a certain period, and then you can have those proceeds setting in my trust account, for instance.
Okay.
And then you determine those assets exempt, and then we would cut a check from our firm to the beneficiary.
Okay. So you keep a trust account. Okay. That makes it easier to disperse funds. What happens if there's multiple heirs determined on the property and they disagree on the sale?
So depending on that, there are two ways that can be addressed. And there's a typical lawsuit referred to as a partition action.
Okay.
And a partition action is when you have an interest in property and you want your fair share, basically. You have to go through the adversarial process. You have to sue them, and you can force the sale through that process.
So let's say there was an investment property, a rental property, and it has tenants. What do you do with the tenants once you've determined what to do with the sale of the home for the probate?
Actually, that hits on a couple of notes. There's a potential tax implication from a capital gains perspective, because that's actually an asset, right? That's accumulating funds. So the idea is you're transferring the ownership to the heirs, and they have the ability to take on the lease, because usually there might be a lease involved. If not, then you go through determination if they're a holder for tenant, if they've paid, something to that effect. And then you can follow through with the lease, depending on what those terms are, or evict them if they're not currently paying clients, or they're not legally.
So a homestead property is not an asset to an estate, but an investment property is an asset to the estate.
Yeah, you get one homestead just like everybody else, and then you could have multiple bits or pieces of real estate that could be investment properties.
What is your recommendation on the first thing a family should do if a loved one passes away?
The first thing you should do is assess the situation. Go to the house, try to see what's there. Try to locate a will. If there is not a will, then you will have to go through the more complicated process of the intestate statute. But once you kind of get your bearings, determining what's there, it's highly recommended to go seek a skilled attorney who specializes in probate to walk you through the process.
What do you recommend someone bring into you when they're coming to meet you for a consult for a probate?
The first thing I recommend is that will, if you find it, and then an idea of who's involved. Is there going to be a disagreement between heirs? Is everybody on the same page with appointing the person who's a person, I should say, that's going to administer the estate? And as much information about the decedent as possible, whether they're creditors, the biographical information about the decedent and things of that nature.
What's one tip you would give a homeowner right now to prepare and protect their estate?
Trust. I would recommend a trust every time, or that enhanced life estate deed. The thing is, when it comes to estate planning, not one size fits all. Everybody's got a unique set of circumstances, so it's best to talk to an estate planning attorney. I might be kind of diamond in the rough because not many attorneys do both, right? So some would just focus on probate, one would just focus on estate planning. But doing both kind of gives us perspective on what could be the pitfalls of estate planning. So you need to speak to a very skilled estate planning attorney to know what's your best options.
Well, and you've seen it all.
Yeah.
You've seen what happens when they don't plan properly and what can happen through probate too.
And there can be a great deal of litigation, and I can tell you I've dealt with the worst of the worst when it comes to families fighting each other.
Yeah. What has been your longest probate case? Everyone has a record.
Oh yeah. I can't take credit for this one because I didn't start it. But 2003 is when I finished, and there were 4 attorneys involved over the years of it being started. But the longest case I've had was 2018. We just closed that one.
You started it when?
2018.
And you just closed it. If you have a loved one that has recently passed away and you don't know where to go or what information to start with, you're not alone. Feel free to reach out. We would be happy to help, give you advice, kind of guide you in the right direction. You can reach out to me, Cassandra Van, with the Home Advisors team at Keller Williams Realty, or
either Google us, the MTM Law Firm PLLC, or you can give us a call at 863-250-2990. And our staff would love to help you and assist any way we can.